Welcome to the Virtual Center for the Study of the Constitution and Civic Responsibility, an ongoing inquiry into American political origins and evolving institutions. The Executive Director of the Virtual Center is Dr. Bill O'Brien. He's also your host for this continuing conversation. Here he is now, Dr. Bill O'Brien.
Thank you, Bob Kincaid, and welcome to this version of the Virtual Center for the Study of the United States Constitution and Civic Responsibility. This is Bill O'Brien, and we've had some technical difficulties here, and I think the technical difficulty is the voice you're hearing right now. That's the major technical difficulty, but be that as it may, I was having a problem getting on the air, but I think we're on now, and it is a pleasure to be with you on this Wednesday. Today is the second day of April. It is a big day in the nation's history in terms of the Constitution of the United States, because once again this morning the Supreme Court weighed in a big way on what the meaning of the U.S. Constitution is about, especially contribute to them. The program that I had in mind anyway was based on the very, very important decision of Citizens United, the 2010 decision. We had talked about that the last time we were together, and it was to be the focus of today's program anyway. And lo and behold, the Supreme Court came out again with another monumental decision in the same area. So we have relevance. I mean, in terms we're perfect. So I really believe that the program that we'll have today, and probably undoubtedly continued into next week as well, will be on this, and I really believe that it'll be very, very important. But it is important also to recognize that these issues are right now just evolving. So this Supreme Court decision was reached a matter of hours ago. So there's going to be a lot of opinion and a lot of conversation related to today's decision. So this is going to be ongoing for a while. So I am very, very pleased to be here. I thank you for the opportunity to be here, and I thank you for your willingness to give us a portion of your time. This is the Virtual Center for the Study of the U.S. Constitution. We've been off the air for a couple of days, and again, these are events or no control. Yesterday, for example, a mudslide knocked down phones and internet service in the region for a number of hours, and we had no internet. Nobody had any internet at all. Now it appears that that's back, but we're vulnerable to a number of issues over which we don't have any control. This morning in class, I teach a class, as I mentioned, on Monday, Wednesdays, and Fridays, and I was teaching students this morning. We were talking about a local street here in the town, in Beckley, the town that I live in, and one of the most gorgeous streets in the region, in town, was a street which runs just parallel to the street that I live on. It's one of the main thoroughfares through Beckley, and what made the street so absolutely appealing was the fact that especially in the summertime, when the sun is high, the shade provided by the trees on both sides of this main thoroughfare just made it absolutely beautiful. It was a pleasure to drive down the street and literally just look at some of the older homes in Beckley on either side. Well, in the last 4 to 5 weeks, the power company has come by and taken down a significant number of those gorgeous trees. Ostensibly, I'm just guessing, but I think I'm right, because the trees were basically into the power lines. And so now what we get, instead of those beautiful trees and the beautiful shadows that they cast, now what we get is a clear view of these very, very appealing power lines running up and down the street. And of course the fact of the matter is they ought to be underground in the first place. But now with the trees gone, they're so much more visible than they used to be, and it just detracts from the whole area. So again, we're dealing with issues and things that we we really, by the time you really got anything going to do something about this, the trees are already gone. So in effect, I mean, we've for the last couple of weeks, people have been raising questions as to why there's so much interference and why there were cones on the road and why the road has been was channeling traffic into single lanes. It's seemingly 2 or 3 days each week for the last 3 or 4 weeks. Well, now we know because in effect, what they did periodically was just move up one side and down the other side of the street, and take down some of the most beautiful trees in the entire region. So, I guess, I mean, I would call it progress, but that's not fair to progress. So I won't do that. It is a pleasure to be with you after not being with you for a while. This is our first and final program of the week. And obviously, with 2 hours before us, it doesn't appear that we're going to be able to do complete justice to the topic at hand today, but we're going to give it a stab, and we'll just continue on into next week. I would love to hear from you on this. This is an evolving issue, and to be very honest with you, it's a very, very complicated issue in terms of constitutional law. As I've mentioned many times, I am not an attorney. I am a historian. And what I know about constitutional history, I've pretty well deduced from taking a couple of courses on constitutional history and doing some reading and a lot of thinking on my own. But I have never been privy to a law course, a regular law course in a law school. People have told me that I think like a lawyer. I used to find that offensive. But I understand. I know now what they mean, and I'm not offended anymore. In fact, I'm complimented by it in a way. But at the same time, I'm very vulnerable when it comes to some of these issues because I obviously am not as privy to the precedents and the content and the concepts. I'll begin today's program with one example of that, and I think you'll understand what I mean. But let me first of all share with you our phone number as well as my email address and invite you to participate actively in our program. Some things that I'm going to be throwing out there are ideas and ways that some of this stuff seems to make sense to me. And if it doesn't make sense to you, or if you see flaws in the reasoning or things that I'm not thinking about or considerations that I really need to reflect upon, then by all means, I hope that you will share those with me, because if obviously I need them, then also our listeners need them as well. So please don't feel that you'll be interfering or interrupting or throwing me off my game or my train of thought or anything else. I can get back on the train. I'm slow, but fortunately for me, the train runs rather slowly as well. So eventually I'll be able to catch up with it. So please don't worry about that. I much more prefer to hear from you and hear your ideas and your suggestions and your considerations and those kinds of things. Because I think all of us together can begin not only to, this is not like a classroom situation where there's going to be a test at the end of the chapter or anything like that. On the contrary, what we're trying to do is get a handle and understand what's going on. Because very honestly, in this particular area that we'll be pursuing today, what's going on is, I believe, is quite disturbing. And I'll share with you some perceptions that seem to drive that point home very, very clearly. But first of all, let me give you the phone number and invite you to share your ideas and your opinions with us, myself included, but particularly our listeners. Our phone number is area code 304-658-3333. That's 304-658-3333. My email address, if you'd like to communicate your thoughts or your ideas to me one-on-one via email, I would love to hear from you. And again, if it looks like something that our listeners ought to hear, then I will reserve the right to print your email, and I'll obviously not identify you unless you want me to do that. And I will print it off and mark it, and then we'll basically touch upon it and share your thinking on the air with our listeners in the next program or perhaps the one after that. So again, my email address, waobrien906@gmail.com. That's waobrien, BRIEN, 906, all one word, no spaces or no punctuation, at gmail.com. Before we get into the topic, I did get an email from Jack, one of our listeners, and I received it the other day. I was going to I received this one this morning, so I was thinking this was one I was going to do yesterday, but then we weren't able to do the program. But this one came this morning, and so let me share with you. And I thought this was particularly interesting, and I wanted to get it on the air, and I wanted Jack to know how much I appreciate his sending this to me. He points out that this morning on C-SPAN today, the 2nd of April, he heard about a discussion in the U.S. House of Representatives on H.R. 2575, which proposes the following. This is under discussion right now in the Republican-controlled House of Representatives. To amend the Internal Revenue Code of 1986 to repeal the 30-hour threshold for classification as a full-time employee for purposes of the employer mandate in the Patient Protection and Affordable Care Act, and replace it with 40 hours. So again, the principle here is pretty clear. Apparently, and this is detail that I'm not aware of, and I appreciate being informed of it. But under the Affordable Care Act, as Jack relates it, it appears that in order to qualify as a full-time employee and therefore to be entitled to healthcare insurance under the Affordable Care Act, 30 hours seems to be the cutoff for employers. In other words, if an employer has an employee who works at least 30 hours on a regular basis, then that person qualifies for health insurance, employer-funded health insurance under the Affordable Care Act. And the legislation under debate in the House would raise that 30-hour mandate to a 40-hour mandate. And I think that's particularly important, because what it obviously suggests is that only people that work 40 hours or more would be guaranteed coverage under the Affordable Care Act. Employers would not be susceptible to a fine for not covering employees that worked 30 hours or 35 hours or 38 and a half, 37 and a half. I know in West Virginia, for example, full-time employment for our state employees is a 37 and a half hour work week. In order to qualify for overtime, time and a half, the person would have to work more than 40 hours. So the 2.5 hour difference between 40 hours and the 37-hour schedule that they work under would be at just regular time. Time and a half would not kick in until 40 hours was exceeded. So that's an example. In West Virginia, for example, in state employees here who regularly work a 37.5-hour week theoretically, excuse me, they would not qualify for health care under the Affordable Care Act, health care insurance, unless they work full 40 hours. Jack makes the point and said, I doubt it would ever go anywhere, because obviously it won't be it will not be supported or approved in the Senate, and undoubtedly President Obama would veto it if it ever got to his desk anyway. So Jack makes the point, and I think it's a good one, that he says, I thought it was an interesting trick. I wonder what the implications might be when considered with other details of the legislation. So again, everything that can be done to derail or to place obstacles in the way of the smooth implementation of the Affordable Care Act continues. And I thank Jack for that insight as to the law. We'll read about it, I'm sure, if it passes the House. But again, chances are that it won't pass the Senate. If it does, it'll be vetoed by President Obama. Given the prospects, given the kinds of things that are happening, it's beginning to look like the fall elections could conceivably become a problem when we say it won't pass the Senate anymore. And the reason for that is because the Democrats control the Senate, at least until November. So it's becoming very clear that that degree of control that the Democrats have in the Senate is increasingly seeming to be very vulnerable. I know that here in West Virginia, for example, one of the Senate seats that seems to be the most vulnerable for the Democrats being able to hold it is the Senate seat here in West Virginia, currently held by Senator Rockefeller, who is retiring. It appears that the Republican candidate for the Rockefeller seat in the Senate, which is current Congresswoman Sheila Moore Capito, has a fairly large lead, at least at this point, in the thinking of the pundits. Although the Democratic challenger, who is also a woman, she's the Secretary of State here, Natalie Tennant, is a very strong candidate, and she just recently has come into the race into the race for the Democratic nomination. So, it's clear that she's going to be a strong challenger to Congresswoman Capito, but whether in fact that it will be strong enough to actually hold on to the seat for the Democrats in the United States Senate is extremely questionable at this point. There's incredible amounts of out-of-state money, big money, coming into the West Virginia. The campaign is well underway, even though it's only the 1st of April, and the election is not until November. There have been campaign ads on television here for the last 4 or 5 weeks at least. So the campaign to unseat, first of all, to win that Senate seat, and second, to unseat the current congressman from this district, who is a Democrat, long-term Democrat, has been in there for about 28 years, Nick Joe Rahal, has been ongoing. And it's very clear that West Virginia is one of those states that Republicans see as a potential pickup in the fall, both in the Congress, to strengthen their hold on the House of Representatives, and also to reduce the Democratic majority in the Senate. And of course, as we know, while the Democrats have had a majority in the Senate, they haven't had enough for the supermajority, which is 60. And so consequently, the Republican ability to filibuster or threaten filibuster has effectively required a 60-vote majority in the Senate in order to really pass anything, which means that even though the Democrats control 56 of the Senate seats, they don't control the 60, which means that they have to depend on a number of Republicans crossing the aisle. But anyway, it's beginning to look, with the fall elections looming, like this might change. But at least in the interim, we can say right now that if this particular piece of legislation to amend the Internal Revenue Code from 30 hours being labeled as full-time employment for employer purposes under the Affordable Care Act, to increase that to 40, while it might pass the House, it, at least at this point, doesn't really have much of a chance in the Senate, and it clearly doesn't have a chance to escape President Obama's veto. But I thank Jack for that information, and it seems to fit very well into the political framework, into the political context, which we see taking shape here as we move toward into the spring and move towards the summer, which is going to be a heavily campaign-focused summer, no question, with the idea that it's entirely likely that President Obama's last 2 years in office might see him working not only with a House of Representatives controlled by Republicans, but with perhaps the Senate being controlled by Republicans as well, which means that theoretically he's probably going to be doing a lot more vetoing than he would otherwise, because the fact that the Democrats currently control the Senate means that A lot of bills get stopped there, and they never make it to his desk. And it's beginning to appear that, at least for his final 2 years in office, there might be a lot more uncomfortable or unpopular pieces of legislation, unpopular with him, reaching his desk than has been during his first administration and during the first half of his second. So again, our phone number is area code 304-658-3333. My email address, waobrien906@gmail.com. I mentioned last time that we were anticipating a program on the Affordable Care Act. And what prompted this was focus on yet another case that has appeared before the Supreme Court, which was argued last week. And this is the famous Hobby Lobby case, where under the religious restrictions in the First Amendment, Hobby Lobby is complaining that its religious freedom is being violated by the Affordable Care Act's mandate that it must provide health insurance funding, a portion of which goes for contraceptive procedures that violate the personal, moral, and religious values of the owners of Hobby Lobby, of the company itself. And so the debate, that case was heard last week before the Supreme Court. It is anticipated that the court's decision will be sometime in mid to late June. And in essence, what this is yet another First Amendment case. This time, though, the issue on the table is not free speech. The issue is religious freedom. And again, it's a case generated by a particular segment of the Affordable Care Act, so-called Obamacare. So there's no question that that piece of legislation over the last 2 years has drawn more political attention and more media attention than probably any piece of legislation that has been passed in a long, long time. And it clearly is becoming the focal point of the potential political divide, if you will, the partisan divide between parties as we move towards the November 2014 elections, off-year elections. And some real changes are happening. I'm not going to go into a lot of detail here because this is really not the point of, not where I'd really like to be with this program. But I think it's important to make this point. Heretofore, the Republicans have clearly made the Affordable Care Act the focus of their campaign. They've made it the focus of their fundraising. They've basically promised that this will be the issue on which they will conduct the coming elections. And consequently, their whole approach and the money that they are raising in local elections is being directed towards trying to link Democratic incumbents, or indeed Democratic challengers if the seat happens to be held by a Republican, but to direct attention politically to link the Democratic candidate in particular elections to the Affordable Care Act. In other words, this person is a Democrat. He or she has a D after their name. Consequently, if they are elected to Congress, they are going to fall under the spell of the Democratic majority in the Senate or the Democratic minority in the House. And the result will be that they're going to become advocates of or supporters of the Affordable Care Act. So what the Republican political focus has been, is that the only way to do damage and to try to derail the Affordable Care Act is to defeat Democrats. And up to this point, more Democrats than not seemingly have chosen to duck this challenge. One of the most, it seems to me, one of the key issues about the Affordable Care Act up to this point is that many Democratic candidates have seemed unwilling to embrace it. They are being pulverized by Republican opponents because they are Democrats. And their response is not to stand up and refute the attacks or try to respond in kind. Their response as well has been to try to distance themselves from President Obama and from the Affordable Care Act by acknowledging that in theory it's a good idea, but we realize there's a lot about it that needs to be fixed and changed and all that. So, you know, in a sense, what they're trying to do is walk both sides of the lines at the same time. They're responding to the attack by equivocating on the degree to which they support the Affordable Care Act. But the reason I mention this is because a different phenomenon has begun to take shape in the last 4 or 5 days, past week, but last 3 or 4 days in particular. And that is that as the sign-up deadline of midnight Monday, March 31st, appeared at the end of last week, as more and more people were being made aware that you only have until midnight Monday to sign up for the Affordable Care Act, the result has been a rush of last-minute people trying to get on board. And the White House has responded by saying that if your effort to apply for health insurance under the Affordable Care Act is in process as of the midnight March 31st, then you will be granted the extension time necessary to complete that application. So in other words, you didn't have to fully comply and be accepted into the program by midnight March 31st, this past Monday. All you needed to be is have your application in process. The result is that there was an incredible last-minute rush over the weekend and through the day Monday, to the point that the computer network broke down a number of times Monday because of the number of people that were trying to access it. But the fact of the matter is, by the time midnight Monday, March 31st, came and went, as we woke up and began to look at the results on Tuesday morning, April 1st, April Fool's Day, ironically, it's very clear that the White House original predictions of something in the neighborhood of 7 million new people receiving health care for the first time under the Affordable Care Act was not an objective without a chance to be reached, but in fact was an objective that was looming as to be possible. It's very likely that when all the numbers are in and all the applications currently in process are completed, the 7 million new signups originally projected is probably not going to be that far off. Already there are well in excess of 6 million. And the last-minute rush has put thousands and thousands of applications in process. So it's entirely reasonable to expect that when all the dust settles, we're liable to be looking at a situation where 6.5 million, or perhaps more, individuals who previously did not have health insurance will now have it. Here in West Virginia, for example, right now, before the deadline rush, and I don't know what the deadline rush was in West Virginia the last 3 or 4 days, but a week ago, 10 days ago, the estimates were that in West Virginia alone, something in the area of 83,000 West Virginians had health insurance under the Affordable Care Act that did not have it before the Affordable Care Act. And so what we're beginning to see is a change in attitude among Democrats. Democrats seemingly have finally come around to the point of realizing, A, I can't run away from this thing, but B, it's beginning to look like I don't want to run away from it anyway because it's looking like it's going to be way more successful than anybody ever dreamed it would be. So for the first time, there are indications that many Democrats who were reluctant to do so before are now beginning to embrace the Affordable Care Act rather than trying to conduct campaigns to distance themselves from it. It seems to me that that is a very, very significant change. How deep it goes, how many Democrats will be affected by it, it's hard to tell. But there's absolutely no question that the climate, the political situation has changed over the last 2 to 3 weeks. Because many people are beginning to see that the Affordable Care Act probably is not going to be the abject failure that Republicans have predicted and continue to predict. I think we have it back. Clearly, I apologize for the interruption. Clearly have a short in the microphone because I jiggled the wires here and got audio back, and it had just failed. And that's what the problem we had at the beginning. I couldn't seem to get any audio on. And so we've got a very, very sensitive situation here. So if you hear me shaking the microphone, it's because we're having a shutdown in the audio. But we've got it back right now, and I apologize for the interruption. We were just winding that particular point up by saying that clearly Democratic willingness to embrace the Affordable Care Act over the last week to 10 days is a very significant change for what was happening prior to that time, because it appeared that while Republicans were continuing to attack the Affordable Care Act and to challenge Democrats by trying to link them to President Obama and to the Affordable Care Act, many Democrats were responding to that not by standing up and defending the Affordable Care Act, but by trying to distance themselves from it by promising their potential voters or prospective voters that they would do everything they could do to make changes in the Affordable Care Act in order to make it better. And it was kind of like, yeah, I'm a Democrat, and yeah, I'm going to be expected to support the Affordable Care Act, but on the other hand, you need to have confidence that I'm not buying the Affordable Care Act the way it is, and I realize that things have to be changed in it, and I promise that I will do that. Well, Democrats have been running that way for a long time. And part of their strategy, of course, was driven by the tremendous difficulty with the startup in October, if you remember that, when the Affordable Care Act sign-up period first began, when the website kept crashing and nobody could gain access and nobody could sign up, and a lot of people were becoming disenchanted, and the startup was an abject disaster, no question. And consequently, the assumption was that the problems with the startup merely mirrored, at least in the part of Republicans, simply mirrored the realities of the Affordable Care Act itself. And just as the startup was a disaster, so was the legislation itself going to be a disaster. That was the Republicans' response. And Democrats really had no answer for that because you couldn't defend the startup. It was a disaster. So Democrats adopted a kind of back-off strategy and hoped to lay low, and maybe this will blow over and these kinds of things. Well, in the interim, what's happened is that so many people have signed up or indicated their desire to sign up for under the Affordable Care Act that suddenly Democratic candidates are beginning to look around and say, hey, this legislation is not a bad thing to run on anyway. I mean, it's looking pretty good. This is a good idea. This is a good program. And that changes the whole nature of the contest. So how this is going to affect what occurs in the fall is anybody's guess at this point. But I think there's absolutely no question that a change in mentality, a change in attitude among Democrats is clearly underway. And while this is not directly related to the issue of the Citizens United and the issue of elections that we talked about going into the program, it's a segment of the same thing. It kind of suggests a facet of some of the partisan hostility and negativism between sides that's going on in and around the Affordable Care Act on the one hand, and now we're looking at the whole issue of the Bill of Rights, the First Amendment specifically, in the other. So what I'd like to do, and again, if you have comments or ideas or suggestions or additions or corrections or whatever that you would like to make on or something that you would like to add to the conversation on the Affordable Care Act, then by all means we invite you to call right now, area code 304-658-3333. We would love to hear from you. But assuming that we're ready to transition into the topic of the day, at least what I intended would be probably the topic of the day. I wanted to go back. We kind of introduced this program the last time we were together, which was a week ago, and so I really need to kind of rehash or review a little bit of that in order to lay the groundwork for what I think the bulk of our program today will be about. I mentioned the Hobby Lobby case, and the Hobby Lobby case was just heard, as I mentioned, before the Supreme Court last week, and the court now has the decision pending, and the pundits, those that monitor the Supreme Court, are anticipating that the court's decision in the Hobby Lobby case will probably come out sometime after mid-June and before the end of June. So, but the connection is that before we can really look at the innards, if you will, whether that's a proper word or not, the internal arguments of that particular case, it seems to me we need to go back and look at the details in a little bit more depth associated with the Citizens United case rendered by the court in 2010. And the reason I say that is because it's the Citizens United case that established the First Amendment precedents associated with the Hobby Lobby case. What Citizens United did in 2010 was eliminate the exceptions that were being made between persons, human beings, and corporations. Citizens United effectively argued that the First Amendment protection of free speech basically needed to shift focus from the speaker to the speech. This is a very, very important, it seems minor, but it is, I believe it is very, very important. The shift in emphasis from the First Amendment protecting the freedom of the speaker to a First Amendment emphasis on protecting access to the speech. And what makes this significant, it seems to me, and this is from, if I told you that I've spent the last 5 days pretty much reading the dissents and the opinions associated with Citizens United, you'll begin to understand that you know, I have all of these things floating around in my head here. And that's why at the beginning of the program today, and that's why right now, I would like to reiterate that if you have opinions or corrections or comments on any of this, please make them, because this is not refined stuff on my part. I'm speculating and trying to make sense out of it just like anybody else. In fact, one of the things that I've said more than once here at the Virtual Center is that one of the things I admire most about the founders is that as you read their writings, it's very obvious that what I find most admirable about the founders is that to a man, they seem to be enmeshed in a process of growth. Their opinions change. They don't reach an opinion and then spend the rest of their lives defending it. They are committed to the idea of the pursuit of truth. Rarely are they willing to come down absolutely and claim that they've found it. Rather, they seem to have an open mind. They're constantly willing to listen to reflect upon, to cogitate on new ideas and new considerations. And if that results in changing their position on a particular issue, they seem more than willing to do that. And I find that admirable. And whereas a lot of people seem to see contradiction in the founders when they change their opinion on a particular issue, I choose to see that kind of change as very positive and very healthy. Because it seems to me that what we're looking at is a mind that is continuing to grow, that is continuing to search and to ponder and to reflect more and contemplate on more different issues, and consequently positions on issues are beginning to reform and change and grow and become a little bit deeper and a little bit more complicated, a little bit broader, and consequently a little bit more significant and a little bit more informative for those of us that are reading and trying to wrestle with some of the ideas and the concepts that they do. That's one of the things that I find admirable about the founders. Well, in effect, the same kind of thing is happening with the Supreme Court. I have to admit, though, that I'm not as encouraged. I don't find this as admirable. And I think before we finish today, I think you'll begin to understand why. But there's no question that what we see happening with Supreme Court interpretations of the Constitution generally and the First Amendment specifically is that there is a process going on, a growth process going on. there's no question that the court seems to be headed in a particular direction. And it is heading toward that objective, if you will, in increments. Decisions are building upon decisions. Decisions are leading to new decisions in new areas. And only when you stand back do you begin to see patterns and see directions and trends. You can begin to anticipate where the court is going by where it's been. I'm not necessarily convinced, though, that this is a growth process. Rather, it seems to me that what we're seeing here is a very, very shrewd, carefully conceived political strategy. And I think there's absolutely no question that a key to that strategy is Chief Justice John Roberts. I think we're beginning to learn more and more and more about Chief Justice Roberts. And we're beginning to find out that his approach, he's in what I call, I don't know if this is a proper word or not, but it seems to make sense to me. He's what I call an incrementalist. He knows where he wants to go. He knows where he wants to take his court. But he's not going to take a leap to get from one point to the other and risk the opposition and the challenge that he would clearly face were he to take such a leap. Rather, he's going gradually, step by step. It's almost like he's tiptoeing across a stream in the woods. And he's stepping from stone to stone to stone to stone. Sometimes it doesn't appear that he's getting to the other side of the stream very quickly. But the fact of the matter is he's getting there, and eventually he'll get there. And that seems to be the strategy that he's employing with the use of the First Amendment. We can see what he's done with previous court decisions that go all the way back to the Marshall Court and even beyond the Marshall Court. And he's building his case based more on where he wants to go than on where we've been. In other words, he's not doing an objective, independent analysis of Supreme Court decisions in order to deduce justification and direction for his next decision. On the contrary, he knows what he wants his next decision to be. And he's retracing his steps through previous court decisions in order to build up a case, to make a case or build a justification for where he wants to take the court. This is not a case of a jurist or a legalist doing independent, unbiased research in pursuit of truth. On the contrary, this is an example, this is a situation of a jurist who knows exactly where he wants to go and is finding ways to employ and to utilize whatever mechanisms, whatever steps, whatever precedents he needs to justify where he wants to go. In that sense, what I've been finding in my reading related to Citizens United over the last several days is that this might be one of the most informative, important court decisions made by the Supreme Court in a long, long time. If you think back constitutionally and historically through the nation's history, you can begin to pinpoint the cases, the particular cases that the Supreme Court rendered in the past that seem to be the most significant and the most meaningful. Many of them appear in constitutional history textbooks. Obviously, the Marbury versus Madison decision in 1803. And many textbooks will point to a series of decisions that the Marshall Court reached in 1819, the Dartmouth College case, Dartmouth College versus Woodward, a number of cases related to the Commerce Clause, Fletcher versus Peck and others. That's not it. Ogden, Gibbons versus Ogden is the Commerce Clause case, and the contract case, the Contract Clause, which is the Fletcher versus Peck. And Marshall seemed to focus on the Commerce Clause and on the contract clause of the Constitution, with an agenda which was to enhance the court's role within the whole government framework itself, but also to enhance the power of the central government to play an effective leadership role in economic development and the economic future of the nation. And then, of course, we have other key decisions, one of the key ones obviously being the Dred Scott decision in 1857. And as we focused here at the Virtual Center, I believe that one of the key, critical Supreme Court decisions in the history of this nation is the Lochner decision in 1905, where the court struck down the New York Bakery Law and took on progressivism. I think that was a significant decision by the court. And then a couple of decisions during the New Deal era, decisions related to civil rights. I'm thinking specifically of the Brown versus Board of Education decision in 1954. There were 8 to 10 major decisions that it seemed to me, if you look back over the nation's history, you could pinpoint as key ones. I see the Citizens United decision falling into that category. I think in years to come, scholars are going to look back on the Roberts Court and are going to look at Citizens United as a major decision in the history and evolution of constitutional meaning in American history. I really believe that. And what the court does in Citizens United, and I'm kind of giving my conclusion first here, but I think it's significant as we move towards the top of the hour. What the court does in Citizens United, which I think is incredibly significant, is that it's shifting the focus of the First Amendment from the rights of the speaker to the rights of society to have access to the speech. You almost need to think about that. It sounds like I'm playing with words, but I'm not. Most of us have looked at the First Amendment. Congress shall make no law respecting the freedom of speech, the freedom of the speech or of press. Most of us, historically, have looked at the First Amendment, free speech, as a focus on the right of a human being to speak freely. The assumption being that the right being protected is the right to speak. The focus of the amendment is on the rights of the speaker, with the idea that we will not condone censorship. We will not allow anybody to inhibit people's right to say anything. But on the other hand, the courts have said people will be liable for what they say. In other words, you can be sued or whatever. But you cannot be censored because our political system absolutely depends upon people's willingness to be free to speak. That's been the focus of the First Amendment from the beginning. The Marshall Court has chosen to change that focus from the freedom of the speaker to the importance of the speech to the preservation and strength of our political process itself. In other words, what needs to be protected is not the speaker's right to speak. It's society's right to hear the speech, to have access to the speech. So what needs to be protected is the speech, not the freedom of the speaker. The sense being, the Citizens United case revolving around the fact that the strength of our political system is in large part based upon the sanctity of the marketplace of ideas. Everybody has a right to contribute their point of view on issues into the marketplace. And the idea being that the competition within the marketplace will render a particular piece of speech either something to be sustained or something to be deleted. But that will be determined within the marketplace. It will not be determined ahead of time by keeping the speech from entering the marketplace. So the Roberts Court's position in Citizen United is that our political system depends on access to speech, access to ideas, the free competition of ideas in the marketplace. Consequently, what Roberts is arguing is that what the First Amendment protects is not the freedom of the speaker to speak. It's the freedom of the listener to hear. If you've got something to say, we need to hear it. And traditionally, what we've done is we've protected your freedom to speak in order that we could hear it. But what Marshall is doing is focusing on the speech itself. Once he makes that distinction, then the logical next step is, if the most important thing is the speech rather than the freedom of the speaker, then it becomes a violation of the First Amendment to distinguish between speakers. In other words, it doesn't matter who the speaker is, whether it's an individual person or whether it's a corporation. For society as a whole, the most important thing is that the speech itself be in the marketplace. Once you put the focus of attention on the speech, then you surrender the right to distinguish between speakers. Once you do that, then you can equate corporations with persons. As being entitled to the First Amendment protections of the Bill of Rights. And here's the incremental part. Once you establish that, then if it's the speech rather than the speaker that needs the attention, then when you look at the other portions of the First Amendment, specifically the rights to religious freedom, is it the individual's freedom to worship that deserves the attention, or is it the religion itself that is the focus of attention? And so what the Roberts Court seems to me to be doing is suggesting that once you shift the emphasis from speaker to speech, then you shift the emphasis in the other parts of the First Amendment from the worshiper to the freedom of the religion itself. Once you do that, corporations have the same right to freedom of religion as they do to freedom of speech in the reasoning of this court. And that's the basis on which Hobby Lobby is making its case. What Hobby Lobby's case is based upon is what the Roberts Court did in Citizens United. What Hobby Lobby is claiming is that my First Amendment rights to religious freedom are not being violated because I'm denied the freedom to worship. What's happening instead is I'm being required by the Affordable Care Act to institute benefits for employees that include things that violate my particular religious value system. To force me to do that is a violation of my religious convictions. So again, it's not my right to worship my religion that is an issue here. It's what I believe that deserves the freedom and the protection of the First Amendment. So because the Affordable Care Act would force employers like Hobby Lobby to fund procedures, contraceptive procedures, which violate the personal moral convictions of the company's owners, founders, then the company argues, based on the same principles as Citizens United, that my particular First Amendment rights to religious freedom are being violated. And of course, the reality is the decision's not coming until May, but the reality is, if the court finds for Hobby Lobby, then what they're basically saying is Hobby Lobby's right to its personal religious convictions trumps the rights of the employees to have access to these particular contraceptive programs, especially since to deny the health care coverage from the employer, from Hobby Lobby, wouldn't deny people access to the procedures. It would just make them go some other way to pay for them. So the employees wouldn't be denied the services in this particular case. What they would be denied is making their employer pay for them. And the court's position, the Hobby Lobby's argument is that when you weigh those two things, the company's position takes precedence over the employee's rights to have access to those procedures paid for by the employer. And so you can see the importance of Citizens United because it becomes the basis upon which the new case is being filed. That's why I believe that the Citizens United case deserves all the attention that we can afford to give it. We're at 6 minutes after the hour. We're going to pause and take a 5-minute break, and I will, as required, I will shake the microphone and make sure that we stay on the air. Again, you are listening to the Virtual Center for the Study of the U.S. Constitution and Civic Responsibility. I invite you to stay with us. We'll be taking a short break. I think it's important because the issues on the table today are issues around which the Virtual Center was created in the first place. Because there's no question that the meaning of our constitutional system is being redefined right now. and we need to be aware of it. We'll be right back after a short break. Thank you, Bob Kincaid, and welcome back to the Virtual Center on the Study of the Constitution and Civic Responsibility. I was really enjoying that music. I really did. And Bob does a wonderful job in picking music that we're going to use for the interlude. I keep thinking back to a program we did a couple of weeks ago when we used some Neil Diamond music, and that was quite different. But Bob's music, especially in the transition from one hour into the others, is usually top of the line. He does a good job. I don't know exactly how. I guess he's got a pretty solid background, a music background, in order to be able to do that. But anyway, it is a pleasure to be with you, to be back with you for our second hour. If you've been with us through the entire hour, then I thank you for staying with us. That says something that's very, very important to me. But if you're just joining us, we sure welcome you to the program. We're looking at some of the Supreme Court activities of late. Specifically, we're looking at, we started our issue, if you want to call it that, our present focus on the Hobby Lobby case, which was argued before the Supreme Court last week. And in order to really look at that case, it became almost critical to go back and look in a little bit more depth at the Citizens United case, since so much of Hobby Lobby's case is based upon the court's decision in Citizens United. And so in doing that, I found come across what I think, again, I don't think that this is anything new. I guess a lot of people knew it. I know attorneys knew it, but I didn't, and that is how controversial, I recognize the controversial nature of Citizens United when I heard the decision. And when you read the decision, you see it as well. But then you begin to realize that there's a lot more to it than that. And the significance, the overall significance of the whole case, it seems to me, is in part revealed by the controversy surrounding it on the court itself. I'll get into some details in a moment to lay that out, to justify that statement. But I really believe the deeper into this case, this decision you go, the more you begin to appreciate just how significant it is. And it became even more significant today with the court's decision this morning in the case of McCutcheon versus Federal Election Commission, FEC. And it deals with political contributions, which is obviously directly derived from the Citizens United decision. So what we're seeing is a series of decisions which are shining the spotlight on different facets of the same process. There's absolutely no question that the conservative majority on the court is taking the court and it is taking the Constitution in a particular direction. And it's doing it piecemeal. It's doing it decision by decision, stone by stone, as the court works its way gradually across that stream from one side to the other. It's very, very important to appreciate this and to get a sense as to really what the court is doing. Now, there's no question that the court is interpreting the Constitution in these decisions. But it does not make sense to conclude that the court is looking at each independent case, at each decision, in isolation from the others. The court is choosing, is cherry-picking cases, because we all know that the court itself makes the decision on which cases it will hear and which cases it will not hear. And so the court is making decisions on which cases to hear based in large part on where it wants the Constitution to go, where it wants to take the Constitution. I think that this is incredibly significant, in part because this is the conservative majority on the court. If your goal is to take the court, to take the nation, the interpretation of the Constitution, from where it is to where you would like it to be. And if you are in the process of doing that, then you are engaging in what traditionally jurists call judicial activism. And the key is that it is conservatives who are doing this. Traditionally, the conservatives have been associated with judicial restraint, and their accusations have been at the progressives, at the liberals on the court for their activism. There's absolutely no question that the costumes have changed, and that the conservative majority on the court are now the activists, and the liberal minority is scrambling around trying to find a way to restrain them. And if you look at the history of the court, it kind of makes sense. Where all of that kind of makes sense. Because conservatives for a long time have argued that liberals were changing the Constitution, were redefining the meaning of the Constitution as they went, based on their argument that the Constitution must be a living Constitution, a living document, which is constantly being refined and updated in order to meet new situations and new challenges. So by definition, liberals on the court have been the ones steering the ship, so to speak. They've been the ones orchestrating change. And it's been conservatives who are trying to minimize that change by arguing restraint. And the best example of that, of course, is the argument for originalism in interpretations of the Constitution, the position articulated clearly first by Judge Robert Bork, and of course currently by Justice Antonin Scalia. So while the court was moving the Constitution, conservatives were trying to slow down that movement by advocating and articulating a defense of restraint. Now that the conservatives have been successful in securing what appears to be a conservative majority on the court, they've become the activists, and the liberals are the ones advocating restraint. I think that says a lot, because most people have associated conservatism with restraint and liberalism with activism. And what we see happening now contradicts that whole assumption, those assumptions. It stands to reason, if the court has moved the Constitution significantly in a particular direction, and if now conservatives have the power to move it back, then by definition they would become the activists. So a lot of this, I mean, it makes sense, but I think it's important to kind of keep it in mind. And again, I would be remiss if I didn't once again make sure that you have the phone number and my email address so that you can weigh in on some of these issues. Our phone number is area code 304-658-3333, 304-658-3333. My email address, waobrien906@gmail.com. waobrien906@gmail.com. I mentioned that I've been doing a lot of reading about Citizens United. Let me give you a little bit of the detail as to where that reading is coming from. if you go to the internet, if you go to the World Wide Web, and you look up the Citizens United decision, you will find that the court's decision in that case was written by Justice Kennedy. As Chief Justice, John Roberts had the prerogative of writing the decision itself, himself, or assigning it to one of the other members of the majority. And again, the decision was a 5-4 decision. Justice Roberts deferred to Justice Kennedy to write that decision. Justice Kennedy wrote the decision in Citizens United, and if you read that decision, you will see that it's in excess of 50 pages. It's a fairly lengthy decision. The dissenting opinion, the minority's dissent, is written by Justice John Paul Stevens. Let me take that back. The minority's dissenting position is assigned to Justice Stevens. But he has the same decision to make for the minority as Justice Roberts did for the majority. Just as Roberts assigned the writing of the decision to Justice Kennedy, Stevens assigned the writing of the decision to the retiring justice in the minority. And I'm drawing a blank here on the name. I apologize for that. But Souter, excuse me, Justice Souter. And it was the final decision before Justice Souter retired. I think that's significant because if you read his dissent, the dissent that he wrote, Justice Stevens signed it. It's listed as a Stevens dissent, but it was really written by Justice Souter. It's 93 pages. So the original decision is 50. The number in my mind is 53. I could be wrong. It could be 51 or something like that. But it's more than 50 pages. And the dissenting opinion is 93 pages. That's approaching 150 pages of content. The significant thing is that so powerful is the dissenting opinion that Chief Justice Robert feels absolutely required to respond to the dissent with his own concurring opinion. In other words, he writes an opinion which is 17 pages long. But again, his opinion is not focused principally on defending the decision of the majority. His concurring opinion is aimed principally at refuting the dissent. It seems clear to me that Justice Roberts recognized that to allow the Stevens dissent to stand unchallenged would do serious damage to the credibility of the court, especially the conservative majority on the court. It would demean the decision itself in Citizens United. it could indeed it could contribute to the public's unwillingness to accept the majority decision in Citizens United as legitimate. So to be not judicial, not juridical, not legalistic, but to be straight up about this, Justice Roberts sets out in his 17-page opinion to destroy the Stevens dissent. Also, Justice Scalia writes a dissenting opinion, which is 9 pages long. Justice Thomas writes a concurring opinion which concurs with the entire decision but thinks it doesn't go far enough in the direction of the conservative majority. The sum total is that in order to cover Citizens United, one must read close to 200 pages of legal jargon in order to fully digest the significance of this case. It is absolutely mind-blowing to me that the dissenting opinion is so powerful that the conservative majority is afraid to leave it unchallenged, to allow it to stand unchallenged. So consequently, both Chief Justice Roberts and Justice Scalia take it upon themselves to tear into the Stevens dissenting opinion in Citizens United. If I can offer my own sense after reading all of this stuff, I would offer the following suggestion, at least as I see it. I would suggest that it is very important to make a clear distinction between the verbs to refute and to deny. I would suggest to you that if you read the original Kennedy majority decision and then you read Justice DeSouter's dissenting opinion, which is not his name on it, it has Justice Stevens' name on it. If you read the original 50-page decision followed by the 93-page dissenting opinion, as I read them, I was left with no choice but to conclude that the dissenting opinion effectively refuted the legal thinking that went into the majority decision in Citizens United. I believe that Justice Souter effectively refuted the major arguments of the majority decision. However, when you read the Scalia concurring opinion and Chief Justice Roberts' concurring opinions, both of them aimed not at the decision, but at the dissenting opinion of Justice Stevens, I would argue that Scalia and Roberts both have not been as successful in refuting the dissent as they are in denying the dissent. Consequently, the difference would be the difference between to refute and to deny. And I would basically make this because I think this is a significant difference. if you are successful in refuting a particular argument, then what that means is you have compiled enough evidence and made a strong enough argument that it calls into question the validity of the original opinion. If you successfully refute it, that means that you are effectively challenging the foundational basis on which the legal opinion, the first opinion, the majority opinion, is based. It means that your dissent is extremely credible. It's more than credible. It calls into question the validity of the original decision. But if you are denying a decision, as Scalia and Roberts are doing in taking on the dissent in Citizens United case, if you are denying it rather than refuting it, effectively what you're doing is lobbing softballs at it, but you're not really doing anything to weaken or shake the foundations on which the dissenting opinion is based. Roberts and Scalia both deny many of the allegations that the dissenting opinion makes of the majority. But I would suggest to you that denying it is not the same as refuting it. Consequently, my conclusion after reading the whole thing, all of them, is that the dissent is solid and needs to be considered seriously. Because what the dissenting opinion does is question the very motives of the majority to the point that it alleges, it charges that the majority decision went way beyond the traditional operating parameters of the Supreme Court. The majority opinion in Citizens United decided issues that the litigants in the original case never even asked for. Consequently, Justice Stevens, the dissenting opinion, concludes that one must conclude that the majority's opinion is based principally on what they wanted to rule, not what the evidence suggested they should rule. In effect, what the dissenting opinion does is accuse the Roberts majority, Roberts, Thomas, Scalia, Alito, and Kennedy, the five of them, of blatant, unadulterated judicial activism. To the point that they made it the objective of the Citizens United decision to strike down the constitutionality of a congressional law and a previous Supreme Court decision that wasn't even on the table. Because they had to get rid of that decision in order to move the court where they wanted to take it. Translation, move the Constitution from where it was to where they wanted to take it. the very first paragraph of the dissenting opinion written by retired Justice Souter, who's gone, so his name's not even there. The dissenting opinion is signed by Justice Stevens, Justice Ginsburg, Stevens, Ginsburg, Justice Breyer, and Justice Sotomayor. Those are the four liberal justices in the minority. The decision opens, the dissenting opinion opens by saying the real issue in this case concerns how, not if, the appellant may finance its electioneering. Citizens United was a conservative group funded in part with Koch brothers money that had made a film, a documentary on Hillary Clinton, who at that time was a senator from New York. The title was Hillary, the Movie. They wanted to run that on cable television on pay-per-view right up to the election. In violation of McCain-Feingold, the Campaign Finance Reform Act, which limited political campaigning 30 days before the election itself. So in essence, the legislation, the McCain-Feingold basically suggested that Citizens United could not, without breaking the law, run the movie Hillary, the Movie, at any time other than the 30 days before the last primary election. Consequently, the movie hadn't been banned. All that was happening is that Citizens United were being required to conform to the law, which was McCain-Feingold. And here's what the dissenting opinion, Justice Stevens' dissenting opinion, says. All that the parties dispute is whether Citizens United had a right to use the funds in its general treasury to pay for broadcasts during the 30-day period. That's the issue on the table. The notion that the First Amendment dictates an affirmative answer to that question is, in my judgment, profoundly misguided. Even more misguided is the notion that the court must rewrite the law relating to campaign expenditures by for-profit corporations and unions to decide this case. In other words, right out of the chute, the dissenting opinion is saying that the majority had gone way beyond what the litigants had even asked for. The case was simple. It could have been decided simple. It didn't have to get into the legality of McCain-Feingold. It didn't have to get into the constitutionality of some of the previous Supreme Court decisions, unless the majority wanted to take the court there. And this dissenting opinion is 93 pages because it sets out to prove that the Citizens United decision, this is me speaking, this is my own conclusion, is as much, if not more, a political decision as it is, or than that is, a legal one. If you conclude that Citizens United is more political than legal, then what you are saying is that the court is treading on territory that it really has no business being in unless you endorsed the concept of judicial activism in a big way. How many times in recent years have we heard conservative jurists and justices, I'm thinking of former Justice Rehnquist and Judge Robert Bork and many of the others, who for years have been blasting the liberal majority on the court for its apparent determination to make law rather than interpret the law. What the minority in this dissenting opinion is saying is that this idea of making law is exactly what the Roberts Court is setting out to do in this decision. And in order to do it, it has to take the court way beyond the parameters of what the litigants in the original case even asked for. The decision says the following. The dissenting opinion says the following. The majority's approach to corporate electioneering marks a dramatic break from our past. Congress has placed limitations on campaign spending by corporations ever since the passage of the Tillman Act in 1907. And the court has accepted the legislative judgment that the special characteristics of the corporate structure require particularly careful regulation of corporations. What Justice Stevens is pointing out in this dissent is that there's a whole paper trail, a track record of cases and legislation going all the way back to 1907 and before that, which demonstrates clearly that in looking at the First Amendment, the courts have always made a distinction between individuals and their right to free speech and corporations. And now the majority is claiming that the First Amendment mandates that those distinctions not be made, and that the focus needs to be on the speech rather than the speaker. And once you make that case, which Kennedy does in the majority opinion, in this case, once you put the attention on the speech rather than the speaker, freedom of the speaker, then you create a situation where there doesn't seem to be any justification for distinguishing between speakers if the real focus is on the speech itself. In other words, the idea is, if the First Amendment focus is on the speech, then it's immaterial who the speaker is, whether it's a corporation or whether it's an individual. One other point. Traditionally, for a long, long time, the courts, and I'm thinking specifically of the Marshall Court here, the courts have argued that corporations are persons because they are comprised of people. Justice Marshall makes the case early on, and this is 200 years ago, that corporations must be seen legally as persons under the First Amendment, because to deny them First Amendment rights would be to deny the people in them of First Amendment rights. Corporations are groups of individuals. And Marshall's position is the mere fact that a group of individual people come together to form a corporation doesn't do anything to deny their individuality as people. So consequently, to limit the First Amendment rights of the corporation would be to limit the corporate rights of the individuals in it. And in response to that, for years, liberals argued that to distinguish corporations from persons, from people, would not deny the members of the corporation their First Amendment freedoms, because there's nothing to prevent them from going out and speaking or writing under freedom of the press or practicing religion or whatever they want to do under the First Amendment as individuals. There's nothing in their role as a member of the corporation that denies them their ability to function as individuals. So consequently, liberals have been arguing for a long time that the argument about corporations is bogus. So again, traditionally, conservatives have been arguing that corporations deserve rights because corporations are comprised of individual people who bring those rights to the corporation. And to deny the corporation rights would be to deny the individual's rights. Conservatives have been arguing that for years. Now, in Citizens United, the whole situation has changed around. Now, the majority is arguing that the corporation's rights are critical, and it has really nothing to do with the individuals who comprise it. The corporation itself is a person, is what they're saying. Consequently, Justice Stevens in the dissent sets out in several pages in this dissenting opinion to deny the personhood of corporations. And of course, the reason he must do that is because the majority decision emphasizes the personhood of corporations. I'm trying to find the place here. The court says, the dissenting opinion says, that part of the majority's agenda is to overrule two previous Supreme Court cases, the so-called Austin case and the McConnell case. And the McConnell case is the Justice McConnell from Kentucky that we know about, who is now minority speaker of the Republican minority speaker in the Senate, a minority leader in the Senate. The Austin decision I want to be particular is Austin versus the Michigan Chamber of Commerce. It was a decision that the Supreme Court reached in 1990. It's called the Austin case. Austin versus Michigan Chamber of Commerce. The McConnell case is 2003, 13 years later. It's McConnell versus the Federal Election Commission. Those cases, both of them, justify the right of legislative limits, caps, on corporate spending and on corporate contributions to political campaigns. There's nothing in the case brought by Citizens United initially that brings Austin and McConnell back on the table. But the majority opinion does that, and Justice Stevens' argument is the reason for that is in order to accomplish what the majority wants to accomplish, they must get rid of Austin and McConnell. The Austin case particularly legitimizes and justifies the rights to legislative control and legislative limits on corporate contributions and corporate spending, based on the idea that big money will destroy and corrupt the election process. As long as that case stands, the majority cannot take the court to where it wants to go, which is to shift the emphasis from the freedom of the speaker under the First Amendment to the speech itself. In order to do that, you've got to get rid of Austin. You've got to overrule Austin and overrule McConnell, because both of them legitimize the constitutionality and the legality of congressional limitations to corporate spending and corporate finance. Consequently, the majority of the court, takes this case into a place that the original litigants didn't even contemplate going. The original case was so simple. It could have been decided so easily and so quickly and so narrowly. But the reality is, if they did that, they would lose the opportunity that the case itself presented. Let me read a conclusion from the decision. Not from the decision, from the dissent. This is what Stevens in the dissent says that the majority of the court did in Citizens United. The majority suggests that, even though it expressly dismissed its facial challenge, Citizens United nevertheless preserved it, not as a freestanding claim, but as a potential argument in support of a claim that the Federal Election Commission had violated its First Amendment right to free speech. By this novel logic, virtually any submission could be reconceptualized as a claim that the government has violated my rights, unquote, and it would then be available to the court to entertain any conceivable issue that might be relevant to that claim's disposition. Not only the as-applied facial distinction, but the basic relationship between litigants and courts would be upended if the latter had free rein to construe the former's claims at such high levels of generality. I want to go back and clarify something. At the very beginning of our program today, I made the point that I'm not an attorney. And a lot of this legal jargon is, very honestly, stuff that I'm not familiar with. So in reading these opinions, both the original opinion and the dissenting opinion and the concurring opinions, I confronted the idea of a facial challenge versus in so-called as-applied challenge. And I kept thinking to myself, what is a facial challenge? What is a facial ruling? And there's probably conservatives listening that know, attorneys out there who know exactly what they are, but I'm not. So I went online and I Googled facial challenge in court decisions, in legalism, in juridical language. And I typed in facial, and of course what you get is all of these things about what you need to do in order to give yourself or to go to a place where you get a facial. And all of these websites about the importance of having a facial and the importance of having clean skin and the importance of combating acne and all these other things that had nothing to do with the Supreme Court. And I kept thinking, how do I find out what a facial challenge is? I can't seem to find out. So finally I said, the heck with it. I'll just keep plugging along, and I'll pretend that word is not important. Well, eventually I came to a place where the court explained the distinction. It makes perfect sense to me now, but at the time it did not. When the court claims that something called a facial challenge, that means a challenge that is substantive. On its face. So in other words, if you challenge something on its face, it means it's basically unconstitutional in substance. But if you talk about an as-applied challenge, it means it can be unconstitutional in one context, but it can remain constitutional in the others. In other words, by attacking it, you're not striking it down as being illegal or unconstitutional. What you're saying is, in this particular situation, it doesn't apply. So it can be unconstitutional here, constitutional in a different context. So the shift that the majority in the case, the Citizens United litigants, the shift they made from a facial challenge to an as-applied challenge, seemingly, according to this dissent, played into their hands, because what it did was give the courts the opportunity to look at each situation that came up that was related to this idea of corporate funding and spending in election campaigns, and decide in every basis whether it was legal or not. And so the dissent is, Stevens' dissent makes the point that the court resorted, the majority resorted to this novel logic so that in virtually any submission it could be reconceptualized as a claim that the government has violated my rights. And each case would have to withstand that challenge every single time. And it would then be available for the court to entertain any conceivable issue that might be relevant to the claim's disposition. So in a sense, what the dissent is arguing is that the majority was playing fast and loose with the judicial rules of procedure in order to take the Citizens United case to where they wanted to take it, which was to strike down Austin and strike down McConnell and strike down the right of Congress to limit campaign contributions at all. And that's what they did. I can't believe that our time is up already. It's 50 now. We have one more minute before we hit the 6 o'clock hour, and I know Bob Kincaid is ready to go. So I'm going to sign off at this point and promise you that we'll be back next week, and we'll really get into this in some detail. This is going to be constitutional history like I've never taught it, like you've probably never experienced it either. So I encourage you to be back with us next week. This is Bill O'Brien for the Virtual Center for the Study of the Constitution and Civic Responsibility. Have a wonderful evening, a wonderful week. Take care of yourself. Be safe. We'll be back. Thank you.